afternoon, ladies and gentlemen. Thank you so much for coming to Chapman Law Group on the website and looking at our video log. We present these so that you have information about a variety of areas in healthcare law and a variety of topics and a variety of legal areas that we can help you with. Today with us, we have Sarah Bazzigalupi, who was one of the members in our regulatory division that deals with administrative law. Good afternoon, Sarah.
Hi, Ron. How are you?
Good. Could you please explain to the members or the audience a little bit about yourself?
Sure. Well, I've been focusing in healthcare law since law school. It was a passion of mine, and I definitely focused on that from an early stage. I graduated from the University of Florida, so I'm a proud Gator. Straight after law school, I immediately got involved with large healthcare entities, specifically not-for-profit entities, and worked in their in-house compliance division as well legal team, just to observe what it means to be on the other side or in the inside. After that, I had the opportunity to join Chapman Law Group, and I'm glad I did. Now I can work with a lot of clients, and a lot of my clients come to me with a very particular issue that is close to my heart today that I would like to talk to you about.
No, you don't have an accent, but I'm told you're also Italian, aren't you?
Yes, I am. I was born and raised in Milan, Italy, and I moved to the United States for college. So that's probably why I don't have an accent, but I can't explain it. You might hear it here and then.
Okay, great. Well, let's talk a little bit about the professional resource referrals. In Florida, they're called IPN and PRN. What do those acronyms stand for, and how are they used in the state of Florida?
Sure. So IPN refers to the intervention project nurses. We call it IPN for short, and PRN is the professional resource network, or PRN for short. These are the impaired practitioner programs in the state of Florida, and they have a direct relationship with licensing agencies like the Department of Health, and they are consultants to the Department of Health for anything that has to do with impairment. And so that's how they're going to get involved. They are impaired practitioner programs and defined as such by statute.
Now, when we say impaired practitioner, I guess a lot of people all of a sudden think of drugs and alcohol, but it means a lot more than that, doesn't it?
That's correct. The term impairment is actually defined by statute, and it's true. Most of the time people associate the word impairment with somebody who has a substance abuse issue, but in reality, the way the Department of Health sees it is anything, a condition that causes a healthcare practitioner to be unable to practice their craft with reasonable skill and safety. So that's to say that they have a condition, and that could be a substance abuse issue, but it could also be a mental health disorder or a physical disability, something that would pose a risk to Florida citizens because it would impede that practitioner's ability to practice at the level and standard of care they need to practice to.
Now, IPN and PRN like to say that they're a fair-minded organization and they're only there to, help the practitioner, but we take exception with that, don't we?
Yes, I agree. And I think it's only natural to want to think of that because they do kind of work as a liaison to help people that have substance abuse issues get into treatment. But the reality is when you realize the reason why they were created and who they're working for, it becomes very clear what their goal is and what their agenda is. And that's just because of legislation. So they are the only impaired practitioner programs in the state of Florida. They are specifically mandated such by law. They work directly with the Department of Health, and they are consultants to the Department of Health. So if one thinks about why the Department of Health was created in the first place, we will know that the department is there to protect Florida citizens and regulate licensure and regulate these professions. Therefore, if these entities are working for the department, then really their goal is to promote the safety and welfare of Florida citizens. they're going to look after that first. That is the reason why they exist. They don't really much care for the consequences of the person's or referee's career or what happens to their license, because it's not their job to be interested in that.
Now, how does somebody get a healthcare practitioner, whether you're a nurse or a physician or a massage therapist or a PT or an OT, how are the ways you get involved with either IPN or PRN?
Well, usually it starts with a referral. I guess a good way to think about it is this: if you are accused by an employer or colleague of being in violation of the Practice Act, it used to be that you were referred directly to the Department of Health for possible investigation. And then these programs were created to basically kind of funnel some of those cases outside of the disciplinary proceedings and into instead these two entities that would then kind of govern what would happen to your case. So again, like I mentioned earlier, it has to involve something regarding impairment. So that's when they're going to be included. It could be if you tested positive for a pre-employment drug screening for something that you don't have a script for. It could be related for a positive test results while you're at work for things that you don't have a script for. It could be because somebody suspects that you are impaired at work, or maybe you've got a DUI. Anything that could alert the department or people working in your field that you may have a problem, and that problem can pose a risk to Florida citizens, then you will be told to refer, or you will be referred directly by your employer.
And those problems could include me being a disruptive physician, and they think that I'm doing that because I have a mental health disorder or something's going on. They could refer me, or botched surgery, or any number of things where somebody thinks your ability is impairing your ability to actually perform good medicine.
That's correct. It could be also, for example, if you are a surgeon and you develop a tremor, maybe as a consequence of Parkinson's or something, but the tremor might be indicative of your inability to practice surgery effectively. And so that could be a reason for referral, or maybe a physical disability that impedes your ability to stand for long periods of time, which we know nurses have to do, for example. So again, it's not necessarily related to drugs and substance abuse or alcohol. It is also mental health, and it is also physical disability.
So let's talk about two tracks. The first track is, let's say I know I have an impairment. I developed Parkinson's. I decided that I drink too much alcohol, or whatever the situation is. There are occasions where, when I know I'm impaired and I want my job protected, that I might want to directly call IPN or PRN and enroll in a program because I feel I need the help, right?
Sure.
What kind of protection does that give me when I do that?
I mean, not much. That's kind of the issue I'm seeing on a daily basis. I think that there's definitely a lot of misconception of what these practitioner programs stand for and what they do. And so I think that it's important for any type of healthcare practitioner to talk to somebody and be informed before they make the call, before they enroll. Because once you do, there's really no way out until they say so. And that's the important key to take away.
Well, let's talk about some of the tools then that IPN or PRN use. One of the basic tools is they put you under a contract, right?
Yes, that's correct.
Explain a little bit about that. What does that mean? And
well, there's a few phases, so I would like to take us back a little bit. The first thing that happens really when PRN or IPN get involved is that they will normally ask the practitioner to sign a refrain from practice form. That is because they want to prohibit you from possibly being and practicing until they can determine what your issue actually is. How they determine Well, legally, they cannot come up with diagnostic decisions. They cannot make treatment decisions. They're simply facilitators. So every decision they make, they usually outsource. They're going to have evaluators that are independent medical practitioners. They have to be board certified. They have to be addiction specialists, and they have to be approved by them, but that's where they will refer you. The first thing they're going to do is refer you to these evaluator, because all their decisions will be based on the assessment of that evaluator.
Well, let's talk a little bit about that before you jump in. These evaluators, while they're independent, they're paid in cash by the individual that's referred. The nurse, the doctor, they're going to have to pay that evaluator $1,200, $1,000, $900 for evaluations.
Yeah, and that sometimes does not include the drug testing either. They will also be subjected to hair, blood, and urine testing also.
And then these evaluators evaluate, find that you, in their opinion, you're impaired. They refer you back to PRN or IPN, and the circle keeps going.
And the circle keeps going. That's exactly right. So another thing that's interesting to note is that you can't just go to any mental health practitioner or addiction specialist to be evaluated. You have to go to the ones that are PRN and IPN approved. And from what I understand, these evaluators, in order to get their approval, they go through a course that is taught by IPN and PRN that teaches them how to complete these evaluations. There's no publicly available information as to what makes a person or an evaluator approved or what would take that approval away. So that's a mystery to us still, but arguably that's in the hands and in the discretion of both IPN and PRN. And the other thing that makes it even, I guess, more restrictive is the fact that you still don't have the opportunity to choose from all of the PRN and IPN evaluators. You can only choose from the 3 that IPN and PRN will send you in an initial letter. So they only give you 3 choices.
So let's now talk about the individual that's referred there, either by my employer, or maybe I go to a board hearing because of something and the board says a condition of me being able to practice is I have to go through PRN or IPN and have them okay me to practice. What happens then? So I get referred, I call them up and I say, you know, the board tells me I have to talk to you. What happens then?
Right. You'll have to sign this refrain from practice form. You'll have to go through with the evaluation. And then what happens after that depends on the assessment of the evaluator. The evaluators have essentially only one job, and the job is to determine whether you are currently safe to practice or if you're not safe to practice. In practicality, what I see a lot is referrals to monitoring programs even without the existence of a formal diagnosis. This is important to understand because it means that you don't need to be diagnosed with anything in order to be referred to these monitoring programs. In fact, they have the ability to refer to IPN and PRN for what they call diagnostic monitoring, and that's kind of a rule-out diagnosis. So if there's not enough evidence to demonstrate that you have an impairment of any kind, the evaluators will still recommend that you enroll in the program and see as a rule out if in 2 years they can establish whether you have a problem or not. And if you're compliant all the way through, then it's all great and good. But if not, they might reassess and they might impose additional restrictions. So
now
it's an ongoing process.
This refrain from practicing, are those things that I can negotiate, things that I can challenge? I mean, what if, for example, I was referred because I fell asleep at my desk for some reason. I don't know why, and so somebody referred me. Am I going to automatically have to refrain from practicing for 3 or 4 months and lose all my income?
Yes, you're going to have to refrain from practice until the evaluator says that you are safe to practice. And the evaluator could very well say that you are, but only upon the condition of you enrolling in a program. Unfortunately, that is non-negotiable. The truth of the matter is the moment in which you go into that evaluator's room, you need to be prepared to hear what you don't want to hear. And not following through with those recommendations will result in IPN and PRN dismissing, closing your case, and referring you right back to the Department of Health for disciplinary proceedings.
Now, all that sounds kind of bleak. If I'm the one that fell asleep at my desk and now my world's turned upside down. But let's say I call you. Let's say I call an attorney first and say, hey, my employer says I have to call these people right now. What's going to be different?
It's going to be different because I will tell you not to call them. You will feel pressured. I think that's the biggest issue. When the employer approaches you and accuses you of something, however wild that is, the natural instinct for anybody is to try to be cooperative because they're afraid of losing their job. And that's really that's not the big picture. Because in order to keep your job, you need to have a license. And this type of accusation does not affect your job immediately. It affects your license, and that's your livelihood forever. So a lot of the times I find that practitioners feel compelled to cooperate with the employer. They hope that if they call IPN or PRN, the employer is going to keep them on as an employee. Most of the times they don't. The employer can very well let you go. It's a liability at that point. It's an at-will employment state here in Florida. They have no reason to keep you on the board. They might choose to see what IPN or PRN wants to do with you. But if your goal and your thought process is, I'm just going to go ahead and refer because I want to make my employer happy, that's a wrong way of thinking. You need to think the bigger picture. What does this mean for my future? The moment in which you enroll, the chances of you being in the program are extremely high, and you're going to be labeled as an impaired practitioner forever. This is something that you'll need to report to the boards every year. It's going to be something that will follow you from one state to the next. If you're a practicing traveling nurse, or if you're a physician that has licensure in other states, it's gonna affect you forever. So I think
if I'm hearing what you're saying correctly, when my employer says, you know, hey, Mr. Chapman, you did this, that, or whatever, and you have to call IPN, or we're going to call, I should never say, okay, I'm going to call. I should
Right.
never call IPN.
You should never call IPN.
I should talk to an attorney first who would give me advice. And I'm assuming some of that advice is, well, are you impaired? Do you think you have a problem? Do you think they can help you? You know, because if they are, then that would be a good place to go, right?
Well, that's right. And there's definitely a personal aspect to these types of cases. I am not the practitioner. I don't know if you identify as having an alcohol or drug or a huge impairment. The truth of the matter is, maybe IPN or PRN is a good place for you to go. But the problem is, more and more times I see people just automatically enroll and they don't know what it means. They don't know the long-term goals. If you're aware that you have a substance abuse issue or a mental impairment or physical impairment and you need assistance, and you're prepared to absorb the cost of what treatment means, the cost of monitoring, what those effects will be on your license and on your career, then maybe it's a good place to go. But you can't just do it blindly. And furthermore, what comes to the employer, they're most likely going to report you anyway. Even if they tell you you should report, they have no incentive to not report because they have to report by law. So they're going to do it either way.
I used to tell clients when I was dealing a lot in this area that if you're not impaired when you sign up, you will be impaired when you get out.
That's true.
Because the program's designed just to cause all kinds of problems. You have to stop all your medications usually. Even
Yes.
if you're on long-term medication for OCD or for depression or anxiety, they want you to go cold turkey.
Yes.
You can't even go to the emergency room when you get sick and get, you know, a painkiller without having to report it within a short period of time.
That's true, Ron. Any type of psychotropic medication or any medication that they deem potentially having addictive effects will be off the table. So it doesn't matter if a lot of my clients, for example, have ADHD medication. Well, that's off the table. You certainly cannot take ADHD medication. Doesn't matter how long you've been taking Adderall. I've had clients who got out of spinal surgery that had a prescription for Percocet be told that they cannot take Percocet.
Now, those are things we can help them with, because we're talking a kind of a bleak picture, and IPN PRN is, but Chapman Law Group has success in helping physicians and practitioners stay out of PRN or
That's
IPN.
correct.
How do we do that? How do we fight this institution that once they grab you, it costs what, between about $3,000 and $9,000 before you get out, depending upon how long your contract, right?
And arguably more, yes, because most of the contracts that I've seen are 2 years or 5 years. A lot of them are 5 years. So that's expensive, and that does not even include, I mean, just the drug testing alone can be upwards of thousands of dollars. But if you are now referred to a housing component treatment program or intensive outpatient, you're gonna be seeing like a lot of money.
So pick any example that you want for our audience, whether we're talking about a physician who's arguably referred because the person gets mad at work, or somebody who tested positive, or somebody who got a DUI, whatever the scenario is, they call your office and they say, look, I'm not impaired. Why should I have to do this? And pick whatever scenario, and then kind of briefly tell our audience, what would we do? Like would you send them to a psychologist that we've worked with to prepare a report? How do you fight back, I guess, is the question.
Well, the thing that people will need to be prepared to is that the best chances of you not being forced into a program is to actually fight against the Department of Health. So that seems a very scary option, because obviously it involves litigation. But if you're in the hands of a firm that has the resources, an attorney that has been around before, the case can get dismissed. And dismissal of a case means that you are not required to report. It's not a disciplinary action. It will not be on your license. It's like it will never have happened. So when I get these types of cases, the goal is to take an aggressive stance from the beginning to push for dismissal of the case. You have the chance to persuade the prosecutor to not bring charges. And then if they still feel like they want to bring charges, you still have the chance to go up against the probable cause panel and argue that this case should be dismissed. We've had success with that. So you told me to pick an example, but I can think of cases that we have gotten that are real cases that we got dismissed. And the one that hit closest to me was probably she was a nurse. She was accused of impairment while at work. She was asked to submit to a drug screening, and she tested positive for opiates and I believe Xanax, but she had valid scripts for all of those things. She's had anxiety from an early age and has components of some depression. She had been following the same physician in PCP from the time she was a teenager. So the Xanax component has always been under, I guess, good medication management. She also had scripts for opiates because she had unfortunately had to undergo spinal surgery. Very, very serious spinal surgery, and all of her surgeons were aware of her medication management, did not find any issue. Despite this, the employer, concerned perhaps, I don't know, maybe protecting their own interest, asked the nurse to refer to IPN. Not knowing any better, that's exactly what she did, and she underwent a medical evaluation with an evaluator, where she disclosed all her medication, her history, her family history. I'm talking in deep information, and also told him that she had a valid medical marijuana card, although she didn't use medical marijuana at that time. And this evaluator concluded that she was safe to practice but needed to be in monitoring, and that she had a mild opiate and sedative use disorder, as well as THC use disorder, and recommended that she be in the program. Now, because she was in the program, she couldn't work, which posed a problem because she had an upcoming spinal surgery to go to. which she couldn't go to because she couldn't leave. And the program also didn't want her to continue making use of the painkillers she was given, despite the fact that there were 5 surgeons telling them that she needed additional spinal surgery. Well, we definitely took that case and brought it to the prosecutor. I think we were able from the beginning to kind of paint the picture of how ridiculous these accusations were and the diagnoses were. And argued with the prosecutor, and then persuaded the probable cause panel and managed to get the case dismissed. So that's a success story, and that is in a situation where there was an evaluation that found her to be required to go into monitoring. Without the evaluation, our job would be easier, but even in those situations where things can seem more dire, there is a chance. You just need to take an aggressive stance and be prepared to fight.
We don't have a lot of time left. Let me ask you just a couple questions. From listening to you, it sounds like for our audience who's thinking about IPN PRN, their employer told them they had to go, they're in it and they don't think they should be, there's hope for them if they call competent healthcare attorneys like Chapman Law Group, like yourself. Is that?
Yeah, I think so. I really do.
Okay. Anything else you'd want to talk about specifically about IPN or PRN before we wrap it up?
Sure. I think that's something that is kind of in the forefront of just the media nowadays is the role of these impaired practitioner programs and what it means for people who actually want to use medical marijuana or have a prescription for medical marijuana, or people who instead are actually making use of CBD. I wanted to bring this up because the legislature is still very confused on how they're going to handle these cases, but really IPN and PRN are not. The bottom line is this: it doesn't really matter if you have a medical marijuana card. That will be a trigger for these entities to try to suggest that you have an impairment problem concerning THC. So I want to caution those. However, I will say it seems like the department takes into consideration the medical marijuana card as a valid defense to why you have THC in your system. What if you don't have a medical marijuana card and you have THC in your system? Well, we've also been finding a lot of cases of people using CBD that is over the counter. It might not be medical marijuana, it just might be hemp. The fact of the matter is there's a chance that you're gonna test positive. It doesn't matter what these products say. Even if it says that the THC levels are so low, I'm finding cases of people testing positive. That is enough for the employer to refer you. That is enough for IPN and PRN to recommend treatment. That is enough for the Department of Health to prosecute you. And so you need to really be careful when you're making use of these products. And if you are making use of these products already and you got caught, you should call, because we can get those dismissed if we start from the beginning and you don't wait too long.
A few more seconds on this one issue. Mm-hmm. I go to Colorado, I go skiing, and I smoke some marijuana. I come back to work, I'm not high, I'm not whatever, and I walk in and they say, good news for you, everybody's taking a drug screen this morning. And I test positive for THC. Do I have hope?
Yes, you do, but you shouldn't tell the employer anything, and you shouldn't call IPN or PRN. You should call Chapman Law Group. The problem with these cases is that it doesn't really matter if it was legal where you used it, or even if you have a medical marijuana card. The employer is going to try to protect themselves, and most employers have a no THC medical marijuana policy. So even if you have a card, it doesn't matter. So it would be wise for you to seek legal assistance when you know that you're going to get drug tested, if you know that it's going to test positive.
Now, since medical marijuana or just marijuana is becoming in use, is that something that Chapman Law Group is on the forefront of fighting for? For example, if I have a couple beers tonight and tomorrow my blood alcohol is 0.02, nobody cares. But if I have a trace amount of THC because I smoke legal marijuana, all of a sudden the book gets thrown at me. Are we behind those folks and we're
We
fighting
are.
for them?
We are. We've seen a lot of legislative change, and it's good to start fighting it even from the small individual cases, but it kind of brings attention to the bigger issue and the fact that the public has changing opinions of what marijuana is and how it can be used. So seems the medical community, and to some extent, the Department of Health and the boards. The problem is that the law isn't there yet. So you need to be smart if you're going to pursue this on how you're going to do it, and you need legal assistance if you get caught in the whirlwind of it, because the fact of the matter is it's still a brand new area of practice, and even employers, the boards, the department, nobody's really sure how to handle it. We do, because we've been there, and we'll just keep pushing the envelope.
Great. Thank you very much, Sarah. Well, that's all the time we have today for talking about IPN and PRN, and we've only scratched the surface. There is so much more to talk about. I think the advice from Sarah is that if you're thinking about it or somebody tells you to call, don't. Call Chapman Law Group or another competent healthcare attorney and help them guide you through, because chances are you shouldn't call them. It's kind of a quicksand that you step into that you can't get out of once you step into it. And we have strategies to prevent you from ever having to get involved in it. So thank you so much, Sarah, for your time. Thank you for tuning in, and we'll see you next time.
Thank you.